Hi everyone, Joe Gentili from Saroff Gentili LLP. So today's video is for EB-5 investors, and particularly EB-5 immigrant investors that invested in a project and feel like they were misled prior to investing into the project, or they feel like their funds were mishandled after the investment. Unfortunately, this is a fairly common occurrence, and sometimes it's frustrating to try to help folks in this situation because the LLC agreements, which govern the relationship, really, it's the contract between the regional centers and the projects and the investors. They're usually very one-sided in favor of the regional centers. And one clause in particular that causes a lot of problems is we see that arbitration clauses are very common in these agreements. So even if you're the victim of a fraud, they've misappropriated your money, you could still be held to an arbitration agreement in a lot of situations, which basically means that you can't bring a case in court. You have to go to an arbitrator. I've seen provisions where the regional center gets to pick who the arbitrator is. I've seen provisions where the losing party has to pay the other party's attorney's fees. So there's a whole bunch of kind of booby traps that are put into these agreements that are meant to basically insulate the regional centers from any responsibility. So that's the bad news. So sometimes we find ways around that, and sometimes you can still go to court, or sometimes an arbitration would make sense. But there is one tool that is basically always available, no matter what language is in the LLC agreement, no matter what the regional center tries to get you to contract away. They can't prevent you from filing an SEC whistleblower tip and getting paid on that. So that's one thing that's not waivable, not contractually. You can't get rid of that with a contract. And the SEC whistleblower program is very powerful. What that program is that if you file an SEC tip through an attorney, so you file what's called a TCR, and in that TCR, you're laying out the facts and you're laying your evidence to show that there was a fraud in the purchase or sale of security, or that funds were mishandled. There's a lot of different violations you could allege. So you lay that out, you lay out the evidence properly, and you lay out how it violates the securities laws. You submit that through an attorney, and you're able to do so anonymously. So what does that mean? It means that the fact that you filed the tip is not like filing a lawsuit. So it's not publicly known that you filed the tip. The targets, or the defendants in the tip, if you want to call them that, they don't know that you filed it either. And the case could play out where the SEC could have an enforcement action on behalf of your tip. They can pay you a reward. And still the public never finds out, and the defendants never find out who brought it. And the SEC will do what they can to protect the anonymity of the whistleblower. There are some situations where the whistleblower's name can be known, but they're pretty rare. So if there's an enforcement action that's fought deeply, and the defendants get documents from the government, or there's criminal action and the defendants get documents from the government, then there are some situations where a whistleblower's identity could be revealed, but they're pretty rare. Okay, the best part of the SEC whistleblower program is the rewards. This is primarily why people do it. So if you have information and you're the first to file it, and the SEC uses that information, and they collect a fine over $1 million from the defendants that you identify, then you're entitled to between 10 and 30% of what the SEC recovers in terms of fines from these defendants. And also, if the SEC recovers more than $1 million, you're entitled to that percentage from what the SEC recovers. but then you're also entitled to percentages of what's called related actions. So if the SEC finds over $1 million, you get that. And then let's say USCIS issues another fine, you also get a percentage of that. So these whistleblower programs can be very lucrative, life-changing amounts of money. It's routine that whistleblower awards go into the millions of dollars, and there are rarer instances where people have been awarded tens of millions of dollars, and even in a couple of cases over $100 million. So the rewards available through these programs can be very enticing. So if you have a situation where you think that you've been defrauded through an EB-5 investment, it's worth it to reach out to an attorney to vet this. So I would not recommend reaching out to somebody that's kind of a more conventional immigration lawyer, because immigration lawyers don't necessarily have an understanding or depth of understanding about the securities laws or how the SEC program operates. So I suggest you reach out to somebody with securities experience or whistleblower experience, ideally somebody that also understands immigration. So, you know, that is a thinly veiled plug for my firm, because we're really one of the few, if only, firms out there that has deep experience in securities laws and also the SEC whistleblower program and immigration. So for those of you that primarily know me for doing immigration work, the first 10 years of my career were focused almost exclusively on securities work and securities class actions. And we've also done a bunch of securities whistleblower cases with the SEC. So we have deep experience in that area as well. And as far as I know, we're one of the few, if not the only firm that has experience in both areas pretty deeply. So if you have any questions on this, I suggest you reach out. And if this video was at all helpful, I hope you subscribe. Thank you. Bye-bye.